Alrighty. So that's legislation. That's one source of law in Australia. The other source of law is common law, judge-made law. And judge-made law is really built on this premise of the doctrine of precedent. The doctrine of precedent is your most important fundamental principle, I believe. And what this means is that like cases should have like results. So if you've got a decision, that decision should be followed in subsequent cases. And the purpose of that is to include certainty in terms of how things will be heard and the outcomes that come from them. So the doctrine of precedent tells us that courts must follow the decisions of higher courts in the same hierarchy or jurisdiction. So if you've got a tier of courts, 3 or 4, the bottom court has to follow decisions of any court that's above it. So if it hears a case that it knows that the higher court has heard a similar fact pattern in, it has to apply the same rules of law as above. You can also see that courts outside the hierarchy may have what we call a persuasive precedent. Just means that they don't have to follow it, but they may go, hey, that's really good law, we're going to apply that. So long as a higher court in the system hasn't made the law already. Let's say Canada or UK may have a decision that we apply in Australia because we haven't had a situation like that in the past, and we go, good system. The UK and Canada are probably the best international jurisdictions to get legal principles from. The US, not so much. And China and Japan is a good country or a bad country? It's a civil law system. So we don't generally take principles from Japan, but there is nothing stopping a judge from saying, I like the way that those cases are dealt with, so long as it's within their realms. Another example of a different hierarchy is Victoria and New South Wales. The Victorian courts don't have to follow New South Wales decisions, although a decision of the Supreme Court in New South Wales will be highly persuasive on the Magistrates' Court in Victoria. The legal minds are just that strong. So it's really important that you understand what the hierarchies are to start with, and I will get to there. So the precedent is really based on this concept of the reason for the decision. Now, a judgment might have 100 pages of stuff, of facts, of the judge rambling. In the past, I've seen judgments that look like they're making a decision one way, and then all of a sudden he came out the other side with something completely out of the odds. But what we're looking for in precedent is the reason for the decision. And to be honest, this can sometimes just be a sentence within 1,000 words. And I'm not going to play this video now because I think the timing isn't great. But we have this question around, is necessity a defence to murder? So R.N. Dudley and Stevens is an older case whereby we've got some sailors who have been shipwrecked at sea, and they're on their little lifeboat floating around in the ocean. There's 3 of them, 4 of them. And they've been out there for a while, so they're starting to get fairly malnutrition. They've run out of food. And one of them is starting to get a little bit sicker than the others. And it happens to also be the youngest and probably the least superior in terms of roles on that ship. So we're talking about the cabin boy. Anyway, the crew members decided that they were to kill the cabin boy and, unfortunately, as gruesome as it is, eat him and survive. So that's what they did. And then when they got home eventually, or when they were eventually rescued, they were arrested for murder because, technically, they have murdered this person for their own survival. So they were trialed for murder. So the question is, if we haven't read the outcome, is necessity a defence to murder? Who believes that it's okay? Who believes necessity should be a defence? Not many. Who believes the other side that, well, there's no defence to murder? So the last ones were correct. The court said, well, it's not a defence to murder. Whose life is more important is not something that we can judge. So they were actually sentenced, and I think at that time was a death penalty, but they were released after 6 months because of the facts around the case. But what this gives us, though, and this is still good law for us, is that the principle is, and this is the reason for the decision and our precedent, necessity is not a defence to murder. So you cannot then now kill someone for necessity because we've got this legal principle that good law says you can't. Similarly, if you can't, let's say it's happened in the past, people speeding to go to the hospital because they're unwell. They get a ticket or a red light camera and they go, well, I was speeding because I had to for my own survival. I'll say, actually, you should have called an ambulance. Yeah, we're sorry that you had a tough time, but it's not a defence. So this is an example of a principle that is law. Sorry. No, all good. No, you're okay. So there's a video of that, but the main thing is to note that we're really concerned with the precedent. So the ratio decidendi is what we call that. The legal proposition which is essential to the outcome of that case. And that's following this principle of stare decisis, which just means we stand by a decision as already settled. That's fair. And then you might also see this term obiter dictum. And what that just means is that in a judgment, the judge will waffle, I'll be honest, and will express opinions. But these opinions aren't necessarily essential to the decision that was made. So they're not binding. Those opinions aren't binding. What's binding is the actual reason for the decision. And as legal scholars, the hardest part is identifying what is the rule, what is the rationale for this decision. Lucky for us, the textbooks do a good job at telling us what the rule is. But when a new case comes out and you don't have those summaries, it's really important that you are able to read through that judgment. And they're getting better to read because the law is getting more accessible. But you need to be able to identify what the principles are. Because when we go to apply legal problems, we're really concerned with what is the rule and how does that fit with our fact pattern. Another precedent that we have today, and this is in contract law, we see Balmain, New Ferry Co. and Robertson. Robertson's a lawyer who was a bit upset that he got held at a ferry. So let's picture Sydney, and there's this ferry that goes between the harbour, and on each side there's these turnstiles that you walk through. This is in 1906, so it's fairly old. But once you go through the turnstile, there's this sign that says no exit without paying 1 shilling, for example. So once you go in the turnstile, you have to pay even if you don't get on the ferry. So Mr. Robertson this day went through the turnstile but missed the ferry. He then decided that he didn't want to go, so he tried to exit. And they said, well, to exit you've got to pay 1 shilling. And he refused, and they held him, in his words, against his will, and was false imprisonment. They didn't let him leave. One thing to note in this case, though, is Mr. Robertson had travelled on this ferry multiple times, nearly every day, and he knew that the conditions of entry were. So the court said, well, sorry, Mr. Robinson, you knew from previous use that this was the case, and because of that, you're presumed to be aware of the terms of the contract from previous dealings. So by not paying the 1 shilling, you were in breach of your contract, and they were entitled to hold you until you paid. The precedent there is that if you have used a service in the past, let's say you've used a hotel room, and on the back of the door is a sign that says, we're not responsible for your goods. If you've been to that hotel room a few times, and even if you haven't seen the sign, you're presumed to be aware of those terms. But if it was your first time at that hotel room, and you hadn't even been in the room, you wouldn't be held to that disclaimer because you wouldn't have been aware of the terms. We'll talk about that in more detail in exclusion clauses in a future week. So there's a few terms that we can talk about with precedent. As I was saying, you've got to follow a higher court, but there is some ways that some creative judges get around this. The first is distinguishing. And what we mean by distinguishing is we're distinguishing between the facts of the case. So we've got good case law that a supermarket is negligent if they don't clean up a spill and then someone falls on that spill. And we had an example in Safeway where an individual was walking into the foyer after it had been raining very heavily and had fallen over. The court said, well, the supermarket owes a duty of care. They didn't fulfill their duty of care in those circumstances, and they were responsible for that injury. Now, let's say we have another case, same fact pattern. It's been raining, the floor's wet, the supermarket does nothing about it. But let's change one fact. Instead of the person wearing runners, they were wearing stilettos. We've got precedent that says, well, the duty of care is there, it's been breached and there's been harm. So a court might follow that precedent, but at the same time they might say there's a distinguishing factor in this case, that being this person's wearing dangerous high heels. So they might say in that circumstance, well, depending on your footwear, might change whether the supermarket is responsible or not, or as responsible. So they distinguish the facts and say they're not the same, and this is why they're not the same, and this is why the decision's different. The other way precedent can be changed is that a higher court in the hierarchy might say, actually, lower court, bad decision, we reject it. We're going to change it. Higher court can always change it. The only one that can't change the law is the High Court, because it is the law. Well, the only court that is at the top of the tree is the High Court. Another one that's not on here is disapprove. And this means that a lower court, even though it's bound by a higher decision, has to follow it. It can't not follow it. If it doesn't follow it, it's going to be in a lot of trouble and it's going to go to appeal. But in their judgment, they might just say, a little note saying, we disapprove of this precedent, we don't believe it is good anymore. Perhaps the circumstances in society have changed. In that case, if I was the lawyer for the side that lost, I'd be going straight to appeal, because what that's signalling to me is that the courts don't believe this is good precedent anymore. I should try my luck at appeal. This is why judgments are really important as well, because it lets us know whether we have avenues or not. Overruling is similar. It goes up to the top and the top says no, changed, and then the bottom ones have to follow it. So precedents are captured in what we call law reports. Historically, something that got collected over time, and what is important for us is being able to read what a case name means. So that's a case name. And then the case will have the precedent in it. Here we've got a case called Grant and Australian Knitting Mills, 1935, 54 CLR 49. Now what does that all mean? So what we can say is the party that is first listed is the party that's bringing the case. They're the plaintiff, or if it's the first instance and it's a criminal case, it's usually the police or the DPP. Or it's someone bringing a case on appeal. It's the person who's bringing the case. The second party is the one that's responding. In this case, it's the Australian Knitting Mills. They're the ones that are being sued. But there is examples where, even though Grant is the one that has suffered an injury here, you might see Australian Knitting Mills first because they lost the first case and then they've appealed it. Because they're the ones bringing it, they become the first named. So Grant has brought this case. The brackets or the well, I can't even remember. I'll just call them brackets as well. The circular brackets versus square brackets give us the year that the case was decided in. So we know that this case was decided in 1935. The numbers and code after that is what's a little bit different and a little bit important though, because it tells us what law report this case is found in. Not as important in this day and age because we can just Google it and it will come up. You just Google Grant and Australian Knitting Mill, you'll get something. But in the olden times, you would have had to go to a library, gone to the Commonwealth Law Report section and pulled out volume 54. So what that code is telling us is that this law report is in volume 54 of the Commonwealth Law Report, and you can find it on page 49, the library. This will change depending on what law reports it's in. The V just means and. The Americans say versus. I'm not precious, but technically it's Grant and Australian Knitting Mills. This was a case where a doctor had bought some long johns and they had some chemical residue on them which caused him to develop a rash. And then he decided to sue them under a consumer law type of arrangement to say that the goods were faulty. And he was successful. So precedent is one thing. You're okay.
Thank you so much.
Precedent's one thing. Common law is one thing. But it's also important to note that we have another thing, I'll stop saying thing, another legal aspect called equity. Now today they're kind of joined because the courts have the power to decide in both common law and equity, but I'll take a step back and explain what equity is. Now something historical has formed here because what was happening is initially the king would hear all the legal cases and make a decision. Eventually he's going, I've got too many cases. He delegated to his advisors, and then they started conducting circuits around England, building up a body of law. Eventually that law was transported back to London and focused on precedent. Because of the doctrine of precedent, it meant that all these decisions that were happening were creating these principles that had to be followed. Now, in some cases, when you applied those principles, it resulted in unfair consequences, or things that just did not really address the concerns of the parties at hand. One thing that's really important to note about common law and the remedies there is that all that you can get is damages. That's called compensation. So at common law, all you can get is money. But we know that there's sometimes you need different remedies. Let's say your neighbour is making too much noise at 2 a.m. You might want compensation, but what's something else you might want? You might want them to stop. At common law, you can't get them an order to stop, but at equity, you can get an order, called an injunction, to stop someone from doing something. So what was happening historically is all these people coming into the common law courts and going, we can't, well, this isn't making sense. So the king at the time set up a separate court of chancery to hear matters of equity. So you could petition to this court to say an outcome under the common law was unfair and unjust. Then this person would hear on equity, and another body of law was created called equity. So common law and equity. Equitable remedies include, like I said, injunction, but it can also include an order to make someone do something called specific performance. But since 1873, courts have the power to hear both common law and equitable principles at once. So you no longer have to go to both or one or the other. I can seek an injunction at the same time in any court. So equity follows some maxims though, and it's important to note that equity will only be implemented in circumstances where the common law result was unfair or unjust or manifestly unfair. So if the common law can address the issue, we don't apply equity. If it can't, the courts can apply equity. And it has a real element of fairness about it, in that you have to bring it in a certain amount of time. You can't delay access to equity, nor should you. If you want something to be done, you want specific performance quickly. If you're trying to stop someone from doing something, you want that injunction quickly. But you also need to come with clean hands and a conscience that is clean. I won't go into too much detail because equity is a nightmare, but the concept of it we see in a lot of our principles, such as trust law. It's not really common law and it's not really statutory law. The concept of someone holding property on the benefit of someone else is a principle in equity. And we'll explore that in terms and remedies and property ownership a little bit in contract law. It's just important to note that it is different to common law, but they're heard at the same time now. So the doctrine of precedent is really built on this concept of hierarchy and the courts that are higher in that jurisdiction. We can see the High Court of Australia, though, is at the top of all jurisdictions in Australia. And then you've got a Commonwealth hierarchy, and then each state will have their own internal hierarchies, depending on the Supreme Courts in those states. And what we mean by that is the concept of jurisdiction. The Commonwealth is a jurisdiction, Victoria is a jurisdiction, New South Wales is a jurisdiction. The states, each individually. And then jurisdiction also refers to this concept of being able to appeal. So some courts can only originally hear a case, where others can hear appeals. So based on a decision that was made lower down, you can appeal higher. Jurisdiction may also mean criminal or civil jurisdiction. And then we've got some specialised courts and tribunals that have limited jurisdiction. Not unlimited, limited. The court system is very adversarial. We've got two lawyers fighting it out. Bam, 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 my facts are better, my rule application's better. They'll just argue the case until the judge thinks or decides one is better than the other, generally. So this is where I come back to my concept of there is no right answer in law, only arguments, because what we've got here is two sides to the one story. We've technically only got one fact pattern, although the facts are sometimes disputed. But you've got two arguments happening at the same time that are both probably of high quality, and the judge has got to decide which one's more persuasive, really. So think of me when I'm marking your assignments as a judge. Throw arguments at me. That's your job. So the Commonwealth system has, at the lowest end of the scale, a federal magistrates court. They deal with small matters, such as bankruptcy, trade practices. So that's the lowest court in the Commonwealth hierarchy. And then one step above that, we've got a federal court, which deals with tax, bankruptcy. If a decision in the federal court is made in relation to bankruptcy, that is then binding on the federal magistrates court when they hear similar cases. In the federal system, we've also got a family court that specialises in family law matters, such as divorces, child orders in terms of custody, division of assets. That court is specialised in family matters. That's its jurisdiction. And then at the top, we've got the High Court of Australia, which is really about interpreting the Australian Constitution. It is very, very hard to be successful in getting a case heard in the High Court. You need to get leave, and you need to show that it's a significant constitutional issue. So yes, you can appeal from the Supreme Court of Victoria to the High Court, but only in certain circumstances where the High Court grants that leave. In Victoria, the judiciary system is established by our constitution, being the Victorian Constitution. You've got the Magistrates Court, very low-level matters. I think they've got a jurisdictional amount of $100,000. So if you're suing someone and you're only suing for $100,000, you can go to the Magistrates Court. If you need more than $100,000, you should probably go up to the county or the Supreme Court. The county court is the intermediate one, so they have a bit higher of a jurisdiction. Then we've got the Supreme Court and the Supreme Court of Appeal. Supreme Court of Appeal is the highest court in the Victorian system. Magistrates is the lower. So we know that, unfortunately, the list is bottom up, but flip it around, and anyone below the Supreme Court has to follow the decisions that are made there. That hierarchy and that concept of jurisdiction is incredibly important for the MCQ. And understanding that a different hierarchy isn't binding on a hierarchy that's not part of. So New South Wales is not binding on Victoria. In addition to courts, we're seeing increasingly the use of tribunals. And the reason for this is they're much less formal, they're cheaper, they're more accessible, and they're much more friendly to, decisions being made quickly. They're generally specialised and enables a panel member or a adjudicator to be an expert in that area. So VCAT is a very good example, where you might have a building dispute. You'll go to VCAT instead of going through the court system. The reason why we do that? Cheap. And we know that the person hearing it actually knows what they're talking about. So each state will have different tribunals. VCAT is the Victorian Tribunal, so Victorian Civil Administrative Tribunal. The Australian one has the AAT. But you may also have specialised tribunals that set up with different jurisdictions. We also have a push for more alternative dispute resolution. What this means is not going to a court at all, or even a tribunal. You'll use different mechanisms to conciliate or negotiate a resolution between the parties internally, and I guess internally of those relationships. The different types of ADR include negotiation. So a dispute has arisen, you just talk to the other party. Yeah, I did stuff up. I didn't provide all the goods I promised I would. Here's $20,000 and take that as payment for the damage I've caused. That's a very quick resolution to what could have been an expensive dispute. And I always like to resolve disputes that way because it's cheaper. I'm in-house counsel. I don't want to raise costs. If I was a private lawyer, maybe I would, because you get paid by the hour. They used to get paid by the word, but anyway, that's why all the contracts in the past were so long. Now it's not the case. The other one is mediation. This is my favourite if you're not getting a negotiation, because it puts an impartial person in the room to help guide a discussion into a negotiation. In all of my contracts, I will put a clause in there that says we will try and mediate before anyone goes to court. Then I'm not going to be ending up in court before at least we've got this chance to resolve it in a quick way, cheap way, and conciliatory. This also has a much better opportunity of the relationship continuing. If we want to continue with business with someone, you're probably going to stop when they sue you. Who wants to deal with someone who's suing you? And then conciliation and arbitration. The Americans love arbitration. I'm not a fan because it just creates a binding precedent. It's like a court. I don't like arbitration. But it's the same as mediation, but the person that's independent makes a decision for you, in a way. ADR is much cheaper, generally faster, and another reason why I like it is it's private. Once you go into the court system, it's public. Everyone can see that dispute. So if you're wanting to maintain face, or you've got strategic partnerships that you don't want to show that you're litigious, you're better off getting it sorted behind closed doors. We are nearly there, I promise. It's not technically. The state... No, it's not. So they don't have to follow the rules of precedent. Because what it is really the parties. Arbitration might in some circumstances. And some state functions may support ADR in terms of they pay for it. But think of ADR as alternative to the court hierarchy. Any questions about the hierarchy or precedent? Sources of law? All right. So how do we find the law? There's two ways we can categorize this. The first is primary legal materials, and the second is secondary legal materials. When we're talking about primary materials, we just talk about the actual law itself. So the case or legislation. They are our strongest pieces of authority when it comes to referencing rules. So when it comes to your exams and research assignment, you're best looking at primary legal materials. They're the core authority. Secondary legal materials are your textbook, which are great resources because they do explain what the primary rules are, but they're secondary because they're someone like me writing a book about rules. So they're not the rule. In saying that, this is probably the best place to start secondary materials, because what it will do is it will identify the cases, and then what you'll do is you'll just say that's a primary legal case. So when it comes to your research assignment, you've got a summary at least to start with. So if you've got a case from here, you don't need to reference the textbook, you just reference the case. It's your key to primary legal materials. So that's why there's no excuse to not reference primary legal materials. You might use secondary legal materials to quote something or to show an explanation of something, but stick to primary. Statutory law you can find online very easily. Google is your best friend for statutes. I've got a website there called comlaw.gov.au. If you want to find Commonwealth legislation, you can go to that website and it will bring up those acts in a very easy to access format. And it will even tell you whether that act's still valid or it's been repealed. That's a good spot. Case law, a little bit harder to find, but there is some databases such as OSLI. You can use Google as well, but sometimes it won't bring up the actual case report. It might just bring up a summary, so you might have to dig a bit deeper. So as I was saying, primary legal materials are your best friend. Secondary ones are more persuasive than anything. I'll go over this in much more detail next week. But as a note, legal writing is notoriously difficult to read and understand. As I was saying, lawyers were in the past paid to write by the word or letter or even paragraph, I think it was. So you'd have herein lies therefore, whereas we agree. Those words that make no sense, but they're all joined together to try and say something. We're going to a stage where that's being corrected and we're much more simpler, but just know that it's sometimes really hard to read these materials and interpret them. We'll go over legal writing in more detail in the next couple of weeks, but it's just important to note that it's quite a professional tone. You respond to your research assignment and exams in a way that you would respond to a client. So we try and make it as close to simulated as possible. And we'll talk about that later. Awesome. Any questions? How do we feel? Tired? We can do the Kahoot now, or we can do it next week. Next week? Oh, is that excited for the Kahoot? That's fine, I'm not offended. So next week we start to look at negligence and legal problem solving. So the concept of negligence is really going to go through this building blocks and elements and how the law needs to be proven in elements. If you have any questions during the week, please yell out. Otherwise, have a good rest of your Thursday night and a great weekend.